Thank you very much, Dr. Singhvi. Your fan dance was so good that we thought we'll make you do a little bit more of it sitting down here for 10 minutes or so. You've spoken as a jurist. Of course, this fireside chat is about constitutional morality and the future of democracy. So I'm going to try and wake up the parliamentarian politician as well as part of this conversation. You know, when we speak about constitutional morality, sir, in a sharply polarized political environment, has the definition of constitutional morality and the understanding and the debate around it become so politicized? You say tyranny of the majority. At least the majority in parliament turns around and says, look, this is a political allegation.
So,
No, I think you can go ahead.
can you hear me?
Yeah,
Can you
now-
hear me? Yes. Let me start by saying that when we talked about this fireside chat, you rightly told me not to look at anything and we just have a conversation. The only word you mentioned was constitutional morality. So you have asked actually a political question based upon a completely philosophical and legal concept called constitutional morality. So let me take 1 minute to explain to you what the constitutional legal concept, then we come to the politics of it. You know, Ambedkar, Dr. Babasaheb Ambedkar, used evocative words by saying constitutional morality is not a natural sentiment. It has to be, I'm quoting him, it has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is only a top dressing on an Indian soil, he said. Democracy in India is only the top dressing on an Indian soil, which is essentially undemocratic. Now, constitutional morality, to take half a minute more before I come to a political question, is really a concept of the Greek historian Grote in the 19th century. And he said it is an indispensable condition of government to diffuse constitutional morality. But what does it mean in law? It means the spirit of the Constitution. It means the silence of the Constitution. It means the architecture and scheme of the Constitution, not the text. And it means that those who are holding public office act with a particular and requisite set of virtues which can't be looked at to be found in the text of the Constitution. So you can see that it's a very abstract, bona fide concept about real good governance. Now, having said that, as far as theory is concerned, your question is about majoritarianism versus lack of versus the opposite view. Let me start by saying this is not about questioning the majority's right to govern. Democracy is defined as ruled by the majority. Churchill famously said that democracy is the best form of governance amongst all the worst forms which we have. So it is not a good form, but it's the best available form amongst the worst forms. Now, the crux of the point we miss in terms of constitutional morality is that while the rule of the majority is the meaning of democracy, constitutions are created only for the purpose of entrenching a large number of rights untouchable by the majority. Why would you have a constitution if you had majority rule? The whole idea of a constitutional document is when it says part 3, fundamental right to free speech, fundamental right to trade, this, that and the other, to life and liberty, to religious freedom. These are all anti-majoritarian rights. Mm-hmm. The very reason our founding fathers spent 3 years in creating them and entrenching them was to protect every citizen whether or not he is part of the majority. Whether or not he is part of the majority. Otherwise, every one of these rights can be overridden because you have a majority. So therefore they said, first, some rights are necessarily anti-majoritarian. They need protection against majority will. Second, those can also be overridden, but by special majorities, 2/3. Third, there are some rights which even 100% of the legislators cannot change. Why do you have basic structure? I declare tomorrow that this shall not be a republic but a monarchy. I declare today that only blue-eyed babies shall have the vote. Why can't I do it? I have 90% of the vote. A very good real life example, is the NJAC. We don't have consensus or we have a fractured consensus in Parliament, not even a statute can be passed because we are fractured. But on the NJAC, there was 99% voting, 100% in the Lok Sabha, and 99.9% only Ram Jethmalani got up and voted against. Why was it struck down? Majoritarianism, no? Why was it struck down? These very people struck it down because they are the guardians of the Constitution who are supposed to uphold what they think. Of course, they can be wrong, but they are entrusted with the job of declaring what they think is against the basic structure, and they found that judicial independence is part of the basic structure, and NJAC goes against judicial independence. I'm not debating the judgment. I'm giving an answer about majoritarianism. There is no such thing as majoritarianism simpliciter in a constitutional republic.
No, the point taken, sir, that the courts have always been the custodian of ensuring that the constitutional values and the basic structure is not tampered with. But I'm coming more to the political argument today in terms of trust in the system and trust in the whole process. When there is an attack on the question of the constitution and whether it is under attack and whether constitutional values are being followed or not, when there is such a fierce political atmosphere in terms of questioning that, where does that leave us in terms of what is right and what is wrong? How do we trust, for instance, that the opposition is not using this argument for electoral reasons?
That is the dialectics of democracy. The dialectics of democracy is that you will not write the script for me and I will not write the script for you. Ultimately, now you have asked a political question, I have not, but this is a political session. So we have to speak politics at some point of time. According to me, there is a trust deficit never seen in India as seen for the last some decades. I may be wrong, I may be minority of one, that's my view. That trust deficit is created by a variety of reasons. We don't have time to go into it. According to me, there is a weakening of the non-institutional pillars of Indian democracy. One pillar is secularism. Another pillar is federalism. A third pillar would be all the other non-institutional virtues like fraternity. Then there is a further weakening of the institutional pillars of Indian democracy. According to me, there is a weakening in the judiciary, there is a huge weakening in the media. Maxim is in probably your sector. And, Advaniji would never have thought that his sentence said during the emergency may be temporarily true. We asked you to bend and you crawled. Is possibly 10 times more true today. So, therefore, these are realities whose job is it to reduce the trust deficit, whose job is it to uphold the non-institutional pillars of Indian democracy like secularism, fraternity, federalism, whose job is it to ensure that the pillars of our constitutional system like the army, the CAG, the election commission, the judiciary are imbued with constitutional morality? Well, I think everybody, but above all, the government of the day.
Important point that you're making there, and I'm just being told that we are really short on time. So I just want to bring your attention very quickly to the 130th Constitutional Amendment Bill that we had discussed as well, in terms of people who occupy offices despite facing cases. Now, there is a fierce debate going on into that. Do you believe that the abuse of office or the unwillingness to leave office is something that has led to an amendment of this nature that is essential as is being argued by the government? Or do you believe that there's another side that we're missing in this argument?
Well, I have already written about this. I've been interviewed on this by more than one leading newspaper and I've spoken about it. And you should please discount everything I say because I belong to a political party. Having given those caveats, let me tell you that this particular proposal is all bunkum. Bunkum is the mildest word for it. You are not going to infuse any constitutional morality, which is the duhai you are giving every minute, by having those arrested for month 31 days leaving their constitutional offices. Number one, we know the reality of the power of arrest without the 31-day limit. We know the judgments in theory of the Supreme Court, in law and jurisprudence, and we know the practice on the ground in fair statutes like PMLA, in the IPC and now the BNSS. With that kind of arrest jurisprudence, if you are telling me that a 31-day arrest leads to the departure of a constitutional post holder, actually you are negating democracy completely. This is for a completely different motive. You've asked a political question, so I never hesitate to give you a political answer. The motive is clear, that you are able to control, overawe, threaten, intimidate, scare, create an ambience for everybody who is any manner opposed to you. That includes your allies. That includes even your own governments in states. Because a 31-day arrest amounts to letting a constable nullify the essence of electoral democracy. Chief Minister, Deputy Chief Minister, Minister be damned. This is completely anti-democratic. I hope and trust the JPC will not pass it, despite many parties boycotting it. I hope and trust that better sense will prevail, but this is going to be an example of majoritarian rule, but with one caveat. This requires a constitutional amendment. So you'll find out whether the two-thirds and other theories of majoritarianism will apply here or not, as and when it comes back from the JPC into Parliament.
It's a point that we could discuss forever. There are multiple arguments for it, but unfortunately we've run completely short of time and the fan dance has to end here. But I just want, there are lots of students out here. What do you believe is the key value that they need to inculcate and as they become part of a system that defends and perhaps perpetuates the constitutional morality that you will hand over to them?
If you are talking of the Constitution, or as legal law students, and the constitutional book is the Gita and the Bible for them, I think all that they need to do, partially, incompletely, faultily, is to keep reading the 5, 7, 10 words of the preamble and see to what extent they can inculcate those values. That's the best answer I can give as far as jurisprudence is concerned to law students. Not the political rhetoric. For example, take secularism, one of the most abused words. And I entirely agree it's abused by all sides. The essence of the spirit is different. Professor Bhargav of Harvard University put it very well. He said, in Lincolnian terms, he said, Lincoln used this term, by the people, for the people, and of the people. Then he writes in the next sentence, we can understand by the people because they elect. We can understand for the people because they elect. Right. Why did Lincoln say of the people? He was defining secularism. So he said of the people is supposed to convey a sense of co-ownership of democracy to every human being in a particular system, to the last man in the last row, that sense of co-belonging and co-ownership. Now that's the spirit part of it. And same applies to our least noticed word in the constitutional preamble, fraternity. Actually, secularism and fraternity are partners, whether partners in goodness or partners in crime.
Right. Thanks very much. On that note, Mr. Abhishek Manu Singhvi, we'll leave this conversation here for want of time, but a fascinating conversation both from a legal point of view as well as the political realities.